I was handed my termination papers exactly 90 minutes after I successfully shielded the corporation from a $12 million regulatory disaster. I didn't just save them money in a theoretical sense. I literally blocked a federal indictment that would have liquidated 3 entire divisions and likely sent our chief financial officer to a federal penitentiary. The vendor agreement I flagged that morning was riddled with SEC infractions so obvious they practically glowed in the dark. But Julian Thorne didn't care about legal exposure. He cared about velocity and ink on the page. So naturally, he fired the only person in the building who actually read the documents. But let me back up a bit. In those days, the staff referred to me as the structure specialist. Some used the term with genuine admiration. Others said it with a smirk, as if I were merely the hall monitor of the legal department. I was always present, largely invisible, yet somehow the glue keeping the entire operation from falling apart. My official designation was Senior Compliance Manager. I was 16 years into my tenure at CoreLogic Systems, with 13 years to go until my pension vested, supporting 2 children in university and a mortgage that demanded every cent of my paycheck and every ounce of my patience. I wasn't the type to make noise. I crafted unbreakable agreements. I didn't waste time playing ping pong in the lounge or networking at innovation summits. I lived my life in the footnotes. While my colleagues flirted with catastrophe, I was navigating a minefield of liability triggers, as if my children's tuition relied on it. Because, quite literally, it did. Give me a red correction pen, a 40-page proposal from the sales team, and a mug of stale break-room coffee, and I was happier than a watchmaker finding a loose gear. I enjoyed it. I truly did. And listen, if you've listened this far and you're among the vast majority of people who consume stories like this while commuting or cooking dinner, please go ahead and press that subscribe button. It's not for my ego. I've resolved my legal battles. But the team producing this content relies on your engagement like oxygen. It ensures these stories continue to be told. Anyway, back at the office, I was the tailored suit in a sea of startup hoodies. Never flamboyant, never chaotic, just present. Reliable. I kept our operations lawful, compliant, and silent. These were 2 virtues nobody in the building valued until the walls started catching fire. Julian certainly didn't value them. Julian Thorne, our incoming Chief Operating Officer, was 34 years old, brandishing a prestigious MBA and the specific brand of startup arrogance that rendered veteran employees invisible. He didn't just dislike the legacy staff. He viewed us as barricades blocking his path to innovation. Within his first week, he began bypassing mandatory legal reviews on urgent deals and establishing rapid-fire approval channels that suspiciously excluded the compliance team. I was legacy. That made me a danger, not in a physical sense, but in the I understand your scheme and why it will self-destruct sort of way. Julian didn't want safety rails. He wanted sycophants. He wanted to sign deals instantly, flip partnerships like burgers, and secure a headline in industry journals before the fiscal quarter ended. Me? I simply wanted to read the vendor clause that surrendered our right to litigate in the event of intellectual property theft. Call me antiquated. Before Julian arrived, existence was strangely tranquil. I would begin my morning with bitter coffee and a spreadsheet detailing pending agreements. I appreciated the solitude of the work. How every paragraph was a riddle. Every deal was a potential bomb I could defuse with the precise indemnity phrasing. I spent years constructing a framework where, even if everyone else lost their composure, the contracts would remain stable. I was the anchor on a ship carrying too much sail. They resented that I occasionally dropped the heavy iron to slow us down, but they remained afloat because of it. People often forget this dynamic in corporations like ours. The individual who drafts the rules quietly becomes the most formidable person in the room. They just don't realize it until the trap shuts. Julian swept in with his fancied degree and the sort of unearned confidence that makes board directors nod in rhythm while seasoned workers fade into the background. On day 1, he parked his luxury sedan in the CEO's reserved space, and proclaimed to the staff that we needed to operate at venture velocity. Translation: eliminate the legal oversight, skip the risk analysis, and pray nothing detonates. He was charming in that fast-talking, dizzying way that convinces you to sign away your assets. He possessed a faux humble charisma that captivated interns and reassured investors. The type of man who ended every statement with "does that align?" as if your comprehension was merely a subset of his brilliance. He didn't just ignore the veteran staff, he treated us like spoiled milk. The moment he discovered I had been there over a decade, he smiled as if I had admitted to using a typewriter. "I prefer fresh perspectives," he said once, his teeth perfectly white. People who think differently, which naturally meant people who didn't recall how we were sued in 2018 for the exact same maneuver. Within weeks, he began pushing through agreements like he was swiping on a dating app. The sales division adored him. Product development worshipped him. And legal? We were dropped from conference calls, excluded from deal memos, and forwarded final drafts 2 minutes before the signing deadline. It was like watching a contractor erect a skyscraper without inspecting the bedrock, using dynamite instead of cement. I wasn't panicking yet. 16 years had taught me that organizations go through cycles. Incompetent managers arrive and depart. Solid contracts outlive them all. I continued doing my work, analyzing every sentence, highlighting every hazard, forwarding my meticulous memos up the hierarchy. But Julian wasn't just disregarding the cautions. He was actively circumventing the infrastructure, removing key personnel from email chains, and inventing fast-track protocols that somehow never routed through my inbox. He initiated side negotiations with vendors before the paperwork even reached my desk. The man was allergic to procedure, and in the domain of contracts, procedure isn't bureaucracy, it is survival. That is when I realized this situation wouldn't end with Julian learning a lesson or the board reining him in. This was going to end with a casualty. The only question was whether it would be me, the corporation, or both. As it turns out, I had spent years constructing the perfect snare. I just didn't anticipate Julian would be foolish enough to walk right into it. Then came the breaking point. A vendor agreement landed on my desk, retroactively, naturally. Julian's new favorite tactic was securing signatures first, then sending me the "for your information" copy later. This document didn't just raise red flags, it triggered air raid sirens. On the surface, it appeared to be a fantasy, a strategic licensing partnership with a technology firm in Seattle, clean revenue sharing, reasonable stipulations, a type of arrangement that makes quarterly earnings look beautiful. But concealed within the standard boilerplate was a provision that blatantly violated our non-disclosure agreement with a primary financial backer and could trigger mandatory reporting under SEC Rule 10b-5. That isn't just bad, that is federal court bad. I flagged it methodically and professionally. I sent a memorandum up through the legal department, copied the compliance officer, and even tagged our external risk consultant. I didn't scream. I didn't make it a political issue. I simply outlined the liability exactly as I had done 1,000 times prior. 2 hours later, I was summoned to Julian's office. Let me rephrase. I was summoned to his glass-walled command center, where he enjoyed conducting impromptu meetings like a villain in a reality show. The man was practically allergic to closed doors. I walked in, shut my folder, and took a seat. He didn't offer me a chair. He just leaned against his standing desk, sipping something green and sludge-like from a branded company tumbler. "You have issues with the deal?" he asked, refusing to make eye contact. "It violates 3 existing covenants and would mandate a disclosure to the SEC. We could be." He raised a finger as if hushing a toddler. "Warren," he said my name slowly, deliberately. "You've been employed here, what, 15 years? That is precisely the issue. You perceive barriers where I perceive gateways. This deal propels us forward. Your function is to generate the paperwork, not to second-guess the strategy." The dismissal was calculated, professional, yet dangerous. "The SEC reporting requirement isn't optional," I replied. "It is federal law." Julian leaned back, examining me as if I were a malfunction in the machinery. We require people who solve dilemmas, not manufacture them. Legal archaeology might have functioned in the past, but we are constructing the future here. Stay in your lane and allow the adults to manage the vision. I could have erupted. I could have pulled out the statutes, dropped the evidence like a courtroom drama, but I refrained. I nodded, just a small, deliberate nod, because in that instant, I possessed knowledge that Julian lacked. He believed he was piloting a rocket ship, but I had spent the last 16 years quietly engineering the emergency ejection system, and he had just strapped himself into the pilot's seat. I spent that evening staring at my ceiling fan, replaying his words like evidence footage. Stay in your lane. Legal archaeology. Nobody reads the fine print. My jaw ached from clenching it. Not because he insulted me. That part was anticipated. But because I knew what he was about to unleash upon the organization. And the board of directors was oblivious. I wasn't merely thinking about my position. I was thinking about the multi-million-dollar lawsuits that were going to tear through this building like a tornado in a trailer park. My mortgage, my children's tuition fees. 13 years until retirement, and this man was poised to incinerate the entire operation. So I adhered to protocol because I am protocol. First, I drafted a compliance summary detailing the infractions in that vendor agreement. I cited every paragraph, every SEC disclosure risk, and cross-referenced it with historical precedent. No emotion, no editorializing, just pure risk assessment. Then I escalated it, copying legal compliance and even our internal risk management officer. Quietly. I didn't sound the alarms. I let the data speak, and then I waited. 2 days elapsed. Absolute radio silence. On the third day, I received a calendar invite. Subject line, contract alignment touchpoint, innocuous, dull. Julian's executive assistant sent it as if it were any routine meeting, except it was booked in the primary conference room. The one surrounded by glass. The one typically reserved for investor presentations and product unveils. There were already people inside when I entered. Julian, obviously, arms crossed like a prosecutor. 3 department heads avoiding my gaze, and the company attorney, Rachel Martinez, flipping through a manila folder, her complexion pale under the harsh fluorescent lighting. I stepped inside, no handshake, no chair offered. Julian didn't even wait for the door to latch. "We are terminating your employment," he stated, sounding like he was reading quarterly statistics. "Effective immediately for breach of trust." "Breach of what?" I asked, genuinely baffled. "You operated outside your scope. You escalated confidential transaction details. You are not a compliance officer. You are not a lawyer. You abused internal channels to sabotage executive decisions." I could feel every pair of eyes in the room, attempting to focus on anything else. Rachel's hands were shaking slightly as she clutched the folder. Then Julian reached in and yanked out a copy of my NDA, slapping it onto the table like a weapon. "This agreement includes confidentiality and non-disparagement provisions. Any discussion of internal matters outside approved channels constitutes a violation with personal financial liability." His smile was frigid, calculated. He believed he had just ended my career and my financial stability in the same breath. That is when I saw it. Not the NDA Julian held. Mine. The one I had drafted years ago, back when our former general counsel asked me to revise our standard contract for senior legal staff. We were navigating sensitive regulatory matters at the time, and he wanted anyone raising red flags to be shielded from blowback. That was paragraph 14C. I retrieved a copy from my own folder, not the version Julian possessed, but mine, highlighted in neon yellow, with years of revision notes in the margins. I slid it slowly across the glass table toward Rachel, my finger landing exactly where it needed to be. Section 14C, the Protection Protocol. In the event of termination coinciding with a documented regulatory concern or protected compliance escalation, The company agrees to assume full legal liability and defense costs related to said termination in perpetuity, with no financial cap. Rachel froze. You could witness the precise moment it registered. Her face drained of color, as if someone had severed the power cord. She understood what she was reading before Julian did. Julian was still oblivious. He had just triggered a legal mechanism he didn't even know existed. So I turned to him, my voice steady as granite, and said, "I didn't breach trust, Julian. I followed protocol. And now you have breached the indemnity." He looked to Rachel for backup. She couldn't meet his gaze. The folder in her hands might as well have been a live grenade. I didn't argue. I didn't raise my volume. I didn't ask for a cardboard box or deliver a monologue about fairness. I simply stood up, placed one foot in front of the other, and walked out of that glass fishbowl, while Rachel sat there clutching a document that would cost the company more than Julian's entire annual salary. I didn't slam doors. I didn't weep in the elevator. I didn't cause a dramatic scene and scream about injustice near the break room. I walked out as if I were heading to lunch, calm as a surgeon, my heels clicking against the laminate flooring with the slow countdown. There is a power in silence that loud men never comprehend. Security didn't even escort me out. That was their first error. Back at my desk, I slid my chair in, disconnected my mouse, and opened my laptop. My device, company issued, but personally assigned and legally accessible under my termination clause. I synced my Outlook to local storage, downloaded every flagged memo I had ever sent regarding contract violations, SEC risks, internal NDA breaches, and questionable revenue smoothing language buried in third-party agreements. I wasn't stealing secrets. I was recovering the receipts of my own labor. 16 years of audits, red lines, and escalation emails, all time-stamped, all traceable, all sent through official company channels. I didn't need screenshots. I possessed the metadata. And I closed the lid, walked out, and handed my badge to the receptionist with a smile that probably haunted him for weeks. By the time I arrived home, my inbox was already flooding with messages from former colleagues. The rumors had begun. "Why did Julian look so nervous when you left?" Rachel looked like she had seen a phantom. "Did you write that NDA clause?" I didn't respond. Let them stew. Instead, I brewed coffee, powered up my personal desktop, and spent the next 6 hours organizing my archive. I created folders indemnity, ignored escalations, risk-flagged contracts, SEC violation suspected, and the Julian timeline. I cross-referenced contract timestamps with email alerts. Every time I had raised a concern about shady vendor clauses or misrepresented partnership structures, I linked it to the contract language Julian had fast-tracked. It was like mapping a crime scene with highlighters. And the pattern was repulsive. Julian hadn't just ignored warnings. He had deleted people from threads, bypassed legal review, and shoved contracts through under fabricated urgency. "We will lose the deal. This is how startups move. Don't be the bottleneck." But the worst part? Rachel had seen it all. Maybe not every email, but enough. She had been looped in. She had signed off. Her initials were on files where the risk section was conveniently blank. I wasn't just going up against a reckless COO. I was going up against a corrupted system that had finally started consuming itself. The next morning, I received a cease and desist email. Well, technically it came from HR, but the phrasing screamed Julian. It stated that my behavior, post-termination, may constitute a violation of my NDA, and demanded I cease any communication regarding internal company matters to outside parties. I laughed so hard I nearly spilled my coffee. Then I flagged the email, dropped it into the folder titled Retaliation, and made a note, attempted suppression of whistleblower protections confirmed. I didn't respond. I didn't need to. The indemnity clause had already activated. Their attempt to intimidate me into silence only strengthened my case. From what I heard later, the panic began 3 days after I departed. Legal called an emergency session. Rachel didn't appear. Julian started snapping at people in the corridors. The board sent a routine inquiry about pending contracts. People started asking why the entire new vendor pipeline was frozen. And somewhere in the background, my attorney was sharpening her blade. Her name was Patricia Kane, and she didn't smile unless it was to bare her teeth. Employment litigator by trade, predator by temperament. 3 years ago, I had recommended her to our former general counsel when a VP tried to claim a junior staffer misunderstood the definition of a closed-door meeting. She had settled the case so rapidly it made HR dizzy, and the VP was gone within a week. Patricia specialized in corporate retaliation cases. She had a reputation for turning wrongful terminations into career-ending lawsuits for executives. That is who I called. Patricia, I said, it's time. She didn't need details. She remembered me, remembered the clause, remembered that I had written my own insurance policy years ago. We met at her office the next morning, in a conference room colder than Julian's ambition. I laid everything out in front of her. Email archive, flagged memos, contract discrepancies, the cease and desist. Her eyes moved across each page like a surgeon examining X-rays, looking for the exact point of failure. 15 minutes in, she held up a hand and said, "Stop talking. You have already won. Now we make them understand exactly how expensive this is going to be." Together, we drafted a pre-litigation letter that read like a tactical airstrike. Paragraph 1, Clause 14C, verbatim. The indemnity trigger, the whistleblower alignment, the fact that they were now legally obligated to pay for my legal fees, their legal fees, and any damages, civil or criminal, with no financial cap and no time limit. Paragraph 2, systematic documentation of retaliation, termination following protected escalation, cease and desist attempts as intimidation, SEC-level exposure with federal implications. Paragraph 3. A professional invitation to settle this quietly before federal regulators became involved. We didn't send it to HR. We didn't send it to Julian. We sent it to outside counsel, the firm representing the board of directors. Because here is the thing about Julian. He played checkers loudly, slamming pieces, declaring victory before the board was even set. I played chess, and the queen had finally come off the back line. But I didn't stop there. That same day, I made a personal call. Well, a casual industry update, as we used to call it in legal circles. I rang up Greg Sullivan, a regulatory auditor I had worked with on a prior third-party review. Sharp, ethical, and just inquisitive enough to be useful. "Hey, Greg," I said. "Quick question. What is the threshold again for a company needing to self-report contract violations related to SEC-covered partnerships?" There was a pause. He knew what I was doing. "I would check Form 8K, he said slowly, "and maybe, if I were you, send me something informal. I will decide if it warrants follow-up." I sent him a neatly collated PDF packet within the hour. No accusations, just observations, footnotes, flags. Julian, meanwhile, still hadn't flinched. From what I heard, he thought the cease and desist had scared me off. Told the product team I was emotionally unstable. He smirked in a strategy call when someone mentioned legal being overwhelmed, claiming the board backed his vision. Then Patricia's letter arrived on the desk of the board's legal representative. It was like dropping a carcass on a dinner plate. Within 48 hours, our old outside counsel, a heavy-hitting firm with an allergy to bad press, reached out to Julian. Not with questions, but with silence. Deliberate silence. The kind that fills a room like smoke before a fire alarm. Because the moment the board's lawyers confirmed 14C was real and enforceable, and that all my communications were documented, traceable, and backed by regulatory precedent, Julian became a liability. They didn't call me. They didn't need to. Patricia got the message first. "We are reviewing the matter internally. Please refrain from formal escalation until we have had time to assess." Translation: "We believe you. We are terrified. Please give us a minute to deal with our idiot problem." I didn't pop champagne. I didn't gloat. I brewed a fresh pot of coffee, pulled up the vendor contracts Julian had steamrolled through and began drafting a new timeline. Because this wasn't revenge, this was architecture. A careful demolition of a man who thought rules were optional, and I was just a speed bump. They called it a closed strategic session, but everyone in that building knew what it really was: a panic meeting. No agenda, no minutes, no catered lunch, which for our board was like holding mass without wine. Just 7 silent directors, outside counsel dialing in with grim voices, and a stack of paper 2 inches thick labeled Risk Profile, Immediate Exposure. Julian wasn't invited. That alone set off alarm bells across the company. He found out when his badge wouldn't open a 17th floor elevator. He stormed down to legal like a child locked out of his own birthday party, demanding answers. No one gave him any. Rachel had retreated into a convenient vacation. HR was suddenly unavailable. Even his executive assistant called in sick. Upstairs, the storm was forming quietly. The board's outside counsel began her presentation with a deep breath and no pleasantries. We have received a pre-litigation notification from Warren Pierce. The central issue is Clause 14C of his employment agreement. Board members flipped to the highlighted section. Most had never read past the standard boilerplate, but 14C wasn't standard anything. In the event of involuntary termination following a documented compliance-related escalation, she read aloud, "The company shall indemnify the employee for all legal expenses incurred in defense and counteraction, inclusive of damages, with no financial cap, time limit, or exemption of liability." She let that sink in. This clause was drafted internally by Pierce himself, at the request of our former general counsel. It was reviewed by prior outside counsel and incorporated into 5 NDAs for staff considered mission-critical to compliance infrastructure. The CFO cleared his throat. "What is our exposure here?" "Unlimited," came the reply. "Financially, reputationally, legally." Pierce has 16 years of documentation. His termination occurred immediately after a protected compliance escalation. The executive responsible had full access to both Pierce's NDA and his escalation memos. There is no plausible deniability. "What about settlement?" the chairman asked. "We tried. Pierce ignored our offer completely. He has filed preliminary complaints with both the SEC and state regulators. His employment attorney has a reputation for taking these cases to federal court." The room went silent. In corporate boardrooms, silence means one thing: someone's head is about to roll. One director finally spoke. "What is Brennan's status?" "Suspended, pending review," counsel replied. "But given the liability, exposure, and regulatory interest, we need to consider immediate termination for cause." Down in his office, Julian was pacing like a tiger in a glass cage, still thinking this was about ego, about politics, about a disgruntled staffer too scared to fight. He didn't know they had just reviewed a clause he had signed off on, thinking it was standard NDA boilerplate. He didn't know the indemnity meant I could sue them into bankruptcy on their own dime. He didn't know the board now saw him less like a visionary and more like an active volcano. No one yelled, no one cried. But in that quiet, carpeted room with its leather chairs and filtered water, something changed. They realized they hadn't just fired a contracts manager. They had lit a fuse. And now they were hearing the first hiss of the flame. It came in a cream envelope delivered by courier, like a wedding invitation from someone who hopes you forgot they stole your dog. A letter offering me a generous consulting severance package, 3 months of pay, a signed NDA, and a promise to explore future collaboration opportunities if I just agreed to move on quietly. They even had the nerve to call it a gift. Patricia read it over, chuckled once, and slid it back across the table like it was covered in bacteria. "They still don't get it," she said. "This isn't a negotiation. It's a funeral. They just haven't picked the casket yet." I declined. No drama, no counteroffer, no angry reply. I simply ignored it. Instead, I compiled one final document, the memo. I took my original termination notice, highlighted the timeline of events, attached the flagged contract, my escalation emails, the cease and desist, and the 14C clause. Then I added a cover sheet, submitted in good faith under federal and state compliance protections for review. I didn't even sign my name at the bottom. I let the facts do the talking. Then I hit send. One email to the SEC, one to the state's Office of Financial Regulation, and one to Greg, my auditor contact, who replied 2 hours later with, "Holy hell, buckle up." Back at CoreLogic, legal initiated what they called a comprehensive compliance review. Corporate speak for find out how bad this really is. Behind closed doors, it was a full forensic audit. They reopened every vendor agreement Julian had pushed through, subpoenaed internal communications, and interviewed sales staff about fast-tracked approvals. The results were devastating. Julian had bypassed legal review on 14 separate contracts worth over $40 million. 3 contained SEC disclosure violations. 2 had NDA conflicts with existing partnerships. 1 vendor agreement essentially gave away intellectual property rights that would have taken years to recover. Word spread fast in the tight corporate community. New deal flow froze. Clients sent nervous emails about governance concerns. 1 enterprise partner delayed a $12 million renewal pending clarity on internal processes. Another pulled out entirely, citing regulatory uncertainty. The stock price dropped 8% in 2 days. Industry blogs started asking questions. The SEC's enforcement division sent a formal inquiry letter. Julian, meanwhile, was still trying to play it off as a temporary misunderstanding. He showed up to meetings he wasn't invited to, sent emails that nobody answered, and told anyone who would listen that this was just legacy employees resisting innovation. But his badge had already been deactivated. His corporate accounts were frozen. Security was under orders to escort him out if he tried to access the 17th floor. And me? I didn't show up. I didn't call anyone. I didn't post a LinkedIn essay about resilience or finding new beginnings. I just brewed coffee, sat at my kitchen table, and watched the cracks spread. This wasn't rage. This wasn't revenge. This was what it feels like when the house you built starts pushing back. It hit the wire on a Monday morning. Time to destroy the week before it started. No byline, no direct quotes, just a surgical exposé published by an industry outlet known for burying companies in polite, devastating prose. Headline: COO pushes through risky contracts. Legal retaliation ensues. The article read like it was written by someone with a direct line to my email archive, which, of course, it wasn't. I had never spoken to a reporter. I didn't have to. The evidence had legs. Someone somewhere in the regulatory ecosystem, maybe Greg, maybe someone in the compliance office tired of covering for cowboys, had decided it was time for sunlight. The piece outlined everything with brutal elegance. A pattern of reckless vendor contracts, signed without full legal review. An internal whistleblower raising red flags, then mysteriously terminated. A previously unseen indemnity clause triggering massive internal liability. Regulatory interests now formally engaged, per unnamed sources. They didn't use my name. They didn't need to. Inside the office, panic bloomed like mold in a damp basement. Teams canceled meetings. Executives stopped replying to emails. Legal locked down internal document access for containment purposes. Sales went full mute. And then the domino fell. A respected compliance watchdog, one of those slow-moving, methodical groups whose opinion carries the weight of a Supreme Court ruling in the corporate world, issued a rare public bulletin. A dry, heavily footnoted case study titled Retaliation, Red Flags, and the Cost of Ignoring Internal Compliance. Page 2. This case sets a precedent for how termination, following documented compliance escalation may trigger binding indemnity clauses and potential SEC exposure. There it was, in ink, in the public record. Not just validation, canonization. The board met again 72 hours later. This time, the vote was unanimous. Julian Thorne is terminated for cause, the chairman announced, effective immediately. No severance, no vesting, no references. Julian found out when his badge wouldn't work at the front entrance. Security was waiting with a box containing his personal items and a formal termination letter. Witnesses said he stood there for a full minute, holding the letter like it was written in a foreign language. The industry response was swift and brutal. TechCrunch ran a story titled "When Startup Speed Meets Corporate Compliance, a Case Study." Harvard Business Review published an analysis of the hidden costs of bypassing legal review. Employment law blogs cited the case as precedent for indemnity clause enforcement. A respected compliance watchdog issued a bulletin. This case demonstrates how termination following documented compliance escalation may trigger binding indemnity clauses and potential SEC exposure. Companies should review employment agreements for similar provisions and ensure executives understand the financial implications of retaliating against internal whistleblowers. My name wasn't mentioned in any of the coverage. It didn't need to be. 3 months later, CoreLogic settled with me for an undisclosed amount. The settlement included full legal fee reimbursement, a statement clearing my professional reputation, and a recommendation letter signed by the entire board. Julian, meanwhile, was quietly blacklisted from every major tech firm on the West Coast. I didn't celebrate. I didn't gloat. I just updated my LinkedIn profile and started fielding calls from headhunters who had heard about the structure specialist who had built the perfect legal trap. 16 years of reading fine print had taught me something Julian never learned. In the high-stakes world of enterprise business, the foundation always outlasts the storm. And remember to like the video and mention the channel name Exactly Winds of Thought in the comments if you want more stories like this.